Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here to do an update video on what's going on with the R. Kelly case. And we're going to talk about a couple other things. First, I wanted to start it off. I just found out as I was getting ready to do this video that Snoop Dogg actually issued a formal apology to Gayle King and anybody that he offended.
Top of the morning, Big Snoop Dogg coming at you live and direct with a message. Two wrongs don't make no right. When you're wrong, you gotta fix it. So with that being said, Gayle King, I publicly tore you down by coming at you in a derogatory manner based off of emotions, me being angry at questions that you asked. Overreacted. I should have handled it way different than that. I was raised way better than that. So I would like to apologize to you publicly for the language that I used and calling you out of your name and just being disrespectful. I didn't mean for it to be like that. I was just expressing myself for a friend that wasn't here to defend himself. A lot of people look up to me and they love me and they appreciate me, so I want to let them know that anytime you mess up, it's okay to fix it. It's okay to man up and say that you're wrong. I apologize. Hopefully we can sit down and talk privately. Have a good day.
By his tirade. And the reason I didn't do a video about Snoop Dogg and his tirade against Gayle King and her interview with Lisa Leslie, the women's basketball player, who Gayle kind of like pushed her into tried to push her into the corner, but Lisa Leslie, she came out very calm, cool, and collect. And when Gayle mentioned, the whole rape case from 20 years ago, Lisa was basically like, that's not the person that she knows. And then Gayle tried to push the issue by saying, oh, well, you feel that way because he's your friend. And Lisa was basically like, he was, that commentators or journalists need to leave it where it was. And so the girl who accused Kobe refused to testify. The case was dismissed, and that should have been the end of it. There's no reason to rehash it. And then you guys know that Snoop Dogg came out with this profanity-laced video calling Gayle out for the way she handled the interview, why, she felt the need to bring it up. Gayle, came out with her own two-part video where she was basically blaming CBS for the video, saying that it was a 4-hour interview. And all they posted to social media was a little short clip of the entire interview. And I was sitting there thinking, but isn't that the same thing that you did to R. Kelly when you interviewed him? Like, Gayle strung us along for what, 3 or 4 days. Then they were supposed to have a 1 hour or 2 hour special, giving us the full interview that Friday night. So every morning she kept playing these same little 30-second clips about the interview that was just showing the same thing over and over. Then they created this meme of R. Kelly, jumping up, becoming emotional, and that became the story. And then when she actually had it might have been 1 hour, the 1 hour special on that Friday night, she basically just re-showed the clips that she had been showing during the morning time earlier that week. And so we never did get to see the full, however long that interview was with him. And so why is that any different, Gayle, than what you did to Lisa Leslie by, the network chopping up her interview and then putting together this, short clip? I think it was like a 2-minute clip of, you badgering her to try and say something negative about Kobe. Well, anyway, it was a lot of back and forth. They created this hashtag, all the people that support Gayle and Oprah. Oprah went and did a interview on one of the morning shows, fake crying, pleading, for her friend, saying that, she was being threatened. She had to have security guards. She couldn't sleep at night. And so Snoop Dogg came out with another video that was kind of like a half-hearted apology, kind of, I meant what I said, but maybe I shouldn't have said it the way I said it. And then I guess that wasn't good enough for Oprah and crew, so they put some more pressure on Snoop, probably threatened his money. And so he came out, with a formal apology where he was like basically kissing apology. And so it just goes to show that, no matter who you are, once people start threatening your money, so, then they back down. And that's basically what's happening with the support or lack of support for R. Kelly from people in the industry. They're so afraid that people are going to stop their money that they refuse to stand up, because even in Snoop Dogg's tirade and the people that, supported him and what he was saying, they would say Bill Cosby, they would say Michael Jackson, but none of, they would say Kobe Bryant, but none of them would utter the word R. Kelly, and say that the way they're treating him is wrong. And so for those that are asking, why aren't people speaking up? Why aren't people coming forward? Where are all his friends? Let this be the example of why nobody is speaking up on his behalf. Is because they are afraid that there's going to be these campaigns against them, telling people, not to support them, when, if truth be told, the people that were on social media bashing Snoop Dogg, coming out with this hashtag, I stand with Gayle King, which I thought was hilarious, they basically are not people that were probably supporting Snoop Dogg in the first place. Like, they were not going out buying his music. They weren't going out supporting any gear that he's selling. They probably never watched his show with Martha Stewart. I mean, I don't know, maybe they got to the network and the network threatened to pull the show. Like, you never know what's going on behind the scenes. But basically, that's what happens when you don't see these celebrities speaking up, for injustices and things that are going on, or to say, I don't like the way you're treating my friend. It's because they are afraid of getting their bag took, okay? Then the next thing I was going to talk about was Miss Azriel Clary. Y'all know Azriel out there talking about she in the studio working on her EP. And so she did this video on Instagram where they were supposedly, like, this is how crazy she is, okay? So we all know that R. Kelly comes up with these songs off the top of his head. He goes in the studio with an idea and then just creates a masterpiece, right? So she's on this IG, like she is, this creative genius who's just going to come up with this song just by hearing a melody and a beat. And then she basically, if you really listen to the lyrics, she's trying to throw shade at R. Kelly with this impromptu song that she was putting together. And so I don't know about that girl. She really needs to go somewhere and sit down.
To my girl, man.
We out here.
She's a beast. Shout out to
y'all. We're literally creating music for this EP as we speak. So what you hear, we're actually turning it into a song. So
you know. Shout out to the boy Auntie, BBS.
You guys are a part of the making of the EP for Azriel.
And so the next thing we're going to talk about is people were saying that, they were really happy and excited with the news that came out today that the judge is going to reconsider issuing R. Kelly a bond, and that they hope Steve Greenberg gets it together and he comes strong with the motion. But this really is not a new motion or a new trial for R. Kelly. I'm going to take you guys back. Remember, R. Kelly was supposed to have a hearing. I believe it was on October 29th or 30th or something like that. And he didn't show up for the hearing. And they were actually, it was around the time when Daryl McDavid had presented that motion to dismiss the charges and remove him from the child pornography case that he was indicted on with R. Kelly. And so the judge was supposed to reconsider the bond. And, I think it was back in August or September when they had the first bond hearing about the Illinois case, the Northern District of Illinois. But they put it on hold because they first wanted to see what the New York district, the Eastern District of New York, was going to do. And of course, we know they denied the request for bond for him. And so there was supposed to be a hearing on October 30th. R. Kelly didn't show up. The judge was very upset, and he actually said at that time that he was going to delay giving a response on Daryl McDavid's case and hearing the actual request for release until February. And so that case was supposed to take place this week sometime. I believe it was scheduled for in the morning for the 13th of February. Well, the judge couldn't make that hearing. I think he was going to be out of town or something. And so he delayed. They actually denied the motion that Daryl McDavid put in, and then Steve Greenberg copied the motion and submitted. So they did deny that motion a couple of days or a week ago. And so now they are going to push that hearing from October 30th is now what is taking place on March 5th. And so keep in mind that even if this judge were to say, okay, we're going to give him a bond or release him on bond, you still have New York, who hell would have to freeze over for New York to release him. And so I'm not going to say, don't be hopeful, but just be doubtful that it's going to, that even if he does grant him a release, that he still has to contend with New York, that New York can come in and get him. And so also the Northern District of Illinois federal case was supposed to start, I believe, on April 20th or something. So even though they haven't formally come out and said that that trial is going to be pushed back, you guys can expect that that case is not going to start on April 20th. It's actually going to be pushed back also, because the New York case was pushed back. And so now jury selection is supposed to start. They're going to send out the questionnaires or whatever. I think they said to like 400 people in April or May. I think in May they were going to send out these questionnaires so they can start working towards jury selection. And then they're saying that the New York case is going to begin on July 7th, I believe. So also look to see a notice come out that the Illinois case is probably going to be pushed back also. And then that the Cook County case is going to take place on September 14th. And I remember that date because that is my father's birthday. So I'm highly offended that that case is going to start on that day. Allegedly, it's going to start tentatively, I should say, that is when that case is going to start. I have some motions here that were filed. Let me blow this up so I can read. Where is, oh, here it is. Okay, it looks like the Michael Leonard guy is actually going to be the lead attorney on the Illinois case. And so he filed a motion, and it basically says, please take notice that on February 11, 2020 at 9:30 a.m., I will appear before the Honorable Judge Lineweber at the United States District Court for the Northern District of Illinois. And so we know that that case has been changed to March 5th. And then we have another motion that was sent to this judge, Lineweber. And this says defendant's motion for immediate production of all favorable evidence. And it says defendant R. Kelly, or scratch, defendant Mr. Kelly by and through his undersigned counsel respectfully requests that this court enter an order requiring the government to immediately disclose and produce any and all previously undisclosed evidence or information known to the government or in its possession, custody, or control, the existence of which is known or by the exercise of reasonable diligence may become known, that is favorable to Mr. Kelly and any of his co-defendants and is material in any way to and of the issues relating to defendant's guilt or innocence, or which bears upon the credibility of the government witness who might testify at trial, and state as follows. And so he says, 1, the information and documents referenced above specifically include, but are not limited to, the following: any and all grants of immunity, favors, or promises of any kind made to any witness in connection with obtaining his or her testimony or assistance. This includes any plea agreement entered into between the government and the witness, as a result of which the witness is testifying against any defendant in this case, or on behalf of the government at any other trial, grand jury, or other proceedings, or is otherwise furnishing information to the government. Any assistance, financial or otherwise, provided by any attorney or agent of the government to any witness for any reason, including assistance with local or federal law enforcement agencies or any other agency of federal, state, or local government. The criminal identification and history sheet of each potential government witness. Any criminal charges pending against any potential government witness which have not been disposed of either by conviction or acquittal. Any criminal activity in which a potential government witness has engaged which has not resulted in prosecution or conviction. All mental, psychiatric, or drug abuse and dependency records of any individual who may be called as a witness as trial, including all documents that relate to any such individual's ability to be truthful, forthright, and honest as a witness, to know, hear, see, tell, and relate facts which occur in their presence. All evidence of any payment or reimbursement provided to or for any witness or potential witness. All emails, texts, messaging, and correspondence with any witness who might be called to testify at trial, or with any such individual's attorney, family members, associates, or representatives. Number 2, defendant and his counsel believe this motion regarding favorable evidence in this specificity is necessitated even if the government has already generically indicated an intent and obligation to produce the materials that are the subject of this motion, in light of the ongoing nature of the government's investigation and in light of the government's proclivity to produce these materials on the eve of trial. So basically, all the things that we've been saying they need to be requesting, that's what he's requesting now. Like all these folks that have been to jail, Demetrius and his drug use, like all these shady characters whose testimony they are relying on. They need to know what background information the government has uncovered on these people, because we know that they have access to every criminal court in the United States, and they should have done background checks on these people. And so they need to turn that information over to the defense. And then it goes on to say, wherefore, defendant Mr. Kelly prays for the entry of an order requiring the government to disclose immediately and previously undisclosed evidence or information known to the government or in its possession, custody, or control, the existence of which is known or by the exercise of reasonable diligence may become known, that is favorable in any respect to the defendant or his co-defendants, and which is material in any way to the issues of defendant's guilt or innocence, including but not limited to as described above, and for such other and further relief as is appropriate under the circumstances. And they're respectfully submitted, Michael L. Leonard, counsel for defendant Kelly. And this was actually submitted on February 3rd, 2020. And so they sent that to the judge. And then what else do I have here? I have been pulling this stuff off the system going on 3 weeks now. I'm just not getting around to doing this video. And then here was an order that was issued on February 4th. And it says, order defendant's motion to dismiss count 5 of the indictment. And this was the Daryl McDavid indictment I was telling you guys about, that back on October 30th or 29th, when the judge said that he would hear both this, he would hear about this motion and the motion to have R. Kelly released. And so this was the response to the Daryl McDavid case. Basically, they denied it. And so it says, on July 11, 2019, a grand jury indicted defendants. On October 21st, 2019, defendant Daryl McDavid moved to dismiss count 5 of the indictment. Defendants Robert Sylvester Kelly and Milton Brown later joined McDavid's motion. Defendants argue the indictment is insufficient because the government failed, 1, to identify a qualifying object within the meaning of 18 U.S. Code 1519 to establish the requisite intent, and 3, to establish an overt act in furtherance of the conspiracy within the applicable statute of limitations. For the following reasons, the court denies defendant's motion to dismiss count 5 of the indictment. An indictment passes muster under federal review crime, 12B3, if it states the elements of the charged offense, fairly informs the defendant of the nature of the charge so that he may prepare a defense, and enables him to plead an acquittal or conviction as a bar against future prosecutions for the same offense. United States versus Cox, 536 F.3D 723, 726, and this case was heard in the 7th Circuit in 2008. A motion to dismiss should not be used to assess the strength or weakness of the government's case. United States versus Risk, and this was a case that was heard in the 7th District in 1988. And then they also referenced another case, United States versus Fasnich, which was heard in the 7th Circuit in 2003. And it says that a defendant's constitutional right is to know the offense with which he is charged, not to know the details of how it will be proved. Citation omitted. A court must review indictments on a practical basis and in their entirety, rather than in a hyper-technical manner. Cox, then it goes on with the case numbers. When evaluating sufficiency, the court accepts all allegations in the indictment as true. United States versus Moore, and then it gives the case number, and that was also heard in the 7th Circuit in 2009. An indictment for conspiracy to commit an underlying crime is not equivalent to an indictment charging the underlying crime itself. United States versus Felix, which was held in 1992. The agreement to do the act is distinct from the act itself. The Supreme Court stated that it is well settled that in an indictment for conspiring to commit an offense in which the conspiracy is the gist of the crime, it is not necessary to allege with technical precision all the elements essential to the commission of the offense, which is the object of the conspiracy, or to state such object with the detail which would be required in an indictment for committing the substantive offense. In charging such a conspiracy, certainty to a common intent sufficient to identify the offense which the defendants conspired to commit is all that is necessary. So if you go back, oh my God, I can't remember when this was submitted. Maybe in August I did the video where I actually read the motion that Daryl McDavid submitted, and then Steve Greenberg asked to join the motion, and then the June Brown guy, his lawyers, did the same thing. And they were basically saying that the government, they cited all these cases about what is considered getting rid of evidence, and that the government could not, oh my God, I would have to go back and look at it. But like the example they gave was, if you were fishing and catching fish that you shouldn't be catching, and you saw the police coming and you threw the fish overboard, that wasn't considered getting rid of evidence. And so they were basically using as their foundation the Arthur Anderson accounting fiasco that happened some time ago, where they were charged with discarding this information. And so I guess some of it got thrown out because they were saying that, like, throwing away a computer is not the same as tearing up physical paper evidence that would have been in a file folder. And so if you want that full explanation, you'll have to go back and find that video. Let's see. And I'll try and tag it in this video if I can remember which one it is. So then they go on and they cite another case, Wong Tay versus United States, and this was from 1927, and it says that the Seventh Circuit similarly recognizes a difference between indictments alleging conspiracies and indictments alleging substantive offenses. United States versus Roman, once again in the Seventh Circuit in 1984, then another case, United States versus Khan, which was also in the Seventh Circuit in 1967, finding indictments sufficiently described essential elements of offense. Further, a conspiracy indictment need not be as detailed and specific as an indictment alleging a substantive offense. Count 5 of the indictment sufficiently establishes the charged offense, requires the government establish 3 elements. 1, an agreement to accomplish an illegal objective against the United States. 2, one or more overt acts in furtherance of the illegal purpose. And 3, the intent to commit the substantive offense. And then they cite another case, D'Antoni versus United States, 7th Circuit, 2019. Here, count 5 meets these requirements as it alleges a conspiracy to violate 18 U.S.C. 1519. In count 5's 10 plus pages, the government tracks the statutory elements, provides additional detail as to the parties' agreement, alleges numerous overt acts, outlines the ultimate criminal purposes of the conspiracy, and pleads an offense. See United States versus Locklear, 7th Circuit, 1996, holding that an indictment that uses the language of the statute when setting forth the offense is usually sufficient as long as the statutory language unambiguously sets out all the elements necessary to constitute the offense. Internal citations omitted. This satisfies the government's obligation. Many of defendants' arguments contest the sufficiency and substance of the government's evidence. Specifically, defendants challenge the government's identification of objects under 1519 and ability to successfully prove means RIA. These contentions attempt to hold the government to a higher standard than is required at this stage. The United States versus Augustino, 7th Circuit, 1997, an indictment need not exhaustively recount the facts surrounding the crime's commission or provide details of how it will be proved. Simply tracking the language of the charging statute would generally suffice. Whether the government's proof satisfies the elements is a question for the jury. Thus, the court declines to address these arguments. Defendants also allege the government failed to establish that defendants committed an overt act in furtherance of the conspiracy within the 5-year statute of limitations. But the Grunwald versus United States, the seminal case upon which defendants rely, does not support dismissal. And then they give some case numbers. It says, to indictment that alleged a conspiracy to which one of the criminal objectives was concealment. In Grunwald, the Supreme Court found an agreement to conceal a conspiracy could not be deemed part of the conspiracy to extend its duration for the purposes of the statute of limitations. In that case, the indictment charged not only conspiracy to defraud the United States, but also charged that a part of the conspiracy was an agreement to conceal the acts of the conspirators. The concurrence clarified that, quote, a vital distinction must be made between acts of concealment done in furtherance of the main criminal objectives of the conspiracy and acts of concealment done after these central objectives have been attained for the purpose only of covering up after the crime. Therefore, when the crime's successful accomplishment necessitates concealment, acts of concealment are considered within the scope of the original conspiracy. Such is the case here. Count 5 of the indictment alleges that defendants conspired to knowingly alter, destroy, mutilate, conceal, cover up, falsify, and make a false entry in the record, document, and tangible object with the intent to impede, disrupt, and influence the investigation and proper administration of the matter within the jurisdiction of any department or agency of the United States, and in relation to and contemplation of such matter of or case in violation of 18 U.S.C. 1519. Defendants acknowledge that the statute identified in the indictment defines the scope of the conspiracy. 18 U.S.C. 1519 is not limited to destruction and falsification as cited in the indictment. Concealment is also part of the alleged conspiracy's underlying crime of obstruction of justice. The indictment alleges several overt acts in furtherance of the conspiracy's main objectives occurring within the limitations period. As alleged, defendants did not perform these overt acts to cover up the prior alleged crimes, but rather in furtherance of the conspiracy's main criminal objectives, including to conceal sexual abuse. Therefore, defendants' motion to dismiss count 5 of the indictment is denied. And so I think one of the points that the attorneys was making was that whatever was destroyed, thrown out, discarded, whatever evidence the government claimed that they have, that at the time it was discarded, it wasn't discarded in an attempt to conceal a crime. It just was discarded, and that they should not be able to charge them with destroying evidence if the intent was not there when they discarded or disposed of whatever it was. So I hope that kind of makes sense. It was a long road to get there, but basically that motion that Darryl McDavid submitted was denied. And so I guess that paves the way for him to, I guess, maybe take a plea or turn state's evidence against R. Kelly to avoid jail time, but who knows. Then here is another motion that was filed on February 3rd. This one is defendant's motion to preserve law enforcement notes. Let's see. And so it says, Defendant Mr. Kelly, by and through his undersigned counsel, respectfully requests that this court enter an order requiring the retention and preservation of all notes and reports made during the course of the investigation of this matter. The scope of this request includes, but is not limited to, the notes and reports of all federal agents and all state and local law enforcement personnel that participated in the investigation of any of the events underlying the charges in this case, and states as follows. Let's see. Number one, Mr. Kelly and his counsel request the preservation of all rough notes, memoranda, reports, synopses, text messages, email messages, and videos which were created or compiled as a result of this investigation, regardless of whether their contents were incorporated into any official record or report. Two, Mr. Kelly and his counsel make this request because law enforcement reports sometimes omit material details which were included in rough notes and which are significant to the defense, including under Brady versus Maryland, and that was a case from 1963. And then it says, in addition, rough handwritten notes taken during the course of an investigation or while interviewing witnesses are potentially discoverable at trial pursuant to the Jinx Act. Typically, number four, the government responds to requests for agent notes by stating that there is nothing inconsistent between the rough notes and the final reports that are produced to the defense, and that as a result, there is no need to produce the same information in different formats. That response is not well taken in light of the fact that experience has shown that such inconsistencies often, in fact, actually exist. Number five, therefore, preservation of the law enforcement notes is particularly important given the nature of the government's accusations against Mr. Kelly. Number six, the request is consistent with the Department of Justice directives regarding criminal discovery. Number seven, to ensure that Mr. Kelly's rights to due process and under the Confrontation Clause are not violated, he requests that the court enter an order requiring all governmental law enforcement officials, including state and local law enforcement agencies and personnel involved in the investigation of this matter, to preserve their notes and reports. Wherefore, Mr. Kelly, by and through his undersigned counsel, respectfully requests the entry of the order requiring the retention of preservation of all notes and reports made during the course of the investigation in this matter, and for which other and further relief as is appropriate under the circumstances. And then that too was signed by Michael Leonard. And then I don't remember if I read these. This is from the Eastern District of New York, and I can't remember if I read these to you guys or if I just talked about them, but somebody new might be watching, and so they haven't heard this. But this was actually from New York, okay, and so it says, the defendant is awaiting trial on charges of racketeering in violation of 18 U.S.C. 1962 and 1963, 2 counts of Mann Act transportation to engage in illegal sexual activity in violation of 18 U.S.C. 2421A, and 2 counts of Mann Act coercion and enticement to engage in illegal sexual activity in violation of Code 2422. And then it says, at a status conference on December 9, 2019, the defense asks that the court direct the government to disclose the identities of Jane Doe's number 2 and number 3. On December 20th, 2019, the government asks that I deny the application, ECF number 34. For the reasons that follow, the government's request is granted. And so this is basically in response to the motion to find out the identities of who we have determined. One is Jane Doe number 2. I think I might have said to someone that I thought it was Heather Williams, but then it's actually Patrice Jones. And then the person that's Jane Doe number 3 is actually somebody that that R. Kelly met, and he invited her. So he met while he was out somewhere, probably Atlanta or something, who knows. But he met this woman, invited her to Chicago to do an interview. So she was an intern at a radio station, and it's not the Kitty Jones woman. She was an intern at this radio station, and then in 2003, around that time, he invited her to Chicago to do an interview, and she claims that she was locked in his music studio, couldn't get away, and that somebody came, and I guess she's saying he came in and forcibly had sex with her, and she was held against her will over, certain days. And so I don't think anybody has been able to figure out who this person is. And so the government say that they're not going to release this information. And I thought this was interesting because in the Harvey Weinstein case, there was a lady that was testifying against him, and she mentioned that she had saved this dress that she had on the night that he allegedly assaulted her, and that, his semen was on this dress. And so she actually wasn't one of the people that was accusing him in the case. She was what they call a good faith witness or something, a bad acts witness, meaning that they have had a similar experience with this person. And even though, they haven't received a conviction in their case, they're allowed to come and testify in somebody else's case, which really is just hearsay. And so that's basically how they got Bill Cosby, was that they let all these women who had never filed charges, or the statute of limitations had exhausted on their cases, to come in and testify against him. So this woman is actually going to be a part of the Los Angeles case that returned an indictment over the holidays, where they have a couple of women whose cases they're going to take up in Los Angeles. And so basically, she said she had this dress. The defense had no knowledge of this dress. And so then when they asked about the dress, they was like, oh, and you still have this dress and you didn't wash it. And then they let the defense know, oh, yes, we have the dress, and the dress is being sent to California for forensics testing. So all they had was hearsay about this dress. They didn't have any test results, anything coming back saying that there was semen on the dress or any DNA from Harvey Weinstein on this dress, but this lady was allowed to talk about this dress. And then there was another day during the hearing where they gave the defense the discovery right at the moment. So the prosecution questioned this lady, and then when the defense got ready to cross-examine her, that's when they gave them the discovery. So I think court ended like on a Thursday. They were off that Friday. And so that's when court was ending, they gave the defense the discovery and told them that you can review the discovery over the weekend and try to find, anybody to refute what is being said in the discovery. So get ready, because that's exactly what they're about to do to R. Kelly, making it virtually impossible to defend him against some of these accusations. But if Steve Greenberg is smart, whether he believes that the names that are being thrown out there on Twitter and social media are the Jane Does and Jane Doe number 3, Jane Doe number 2 and Jane Doe number 3, he still needs to be investigating these people and trying to get as much information on the names that are being thrown out there that he can. And so then in this motion of denial, it goes on to say discussion. Rule 7F of the Federal Rules of Criminal Procedures permits a defendant to move for a bill of particulars, quote, before or within 14 days after arraignment or at a later time if the court permits. Whether to grant a bill of particulars rests within the sound discretion of the district court, according to United States versus Torres, which was in the Second Circuit in 1990. And then it says, quoting United States versus Panza, which was in the Second Circuit, 1984. It says, a bill of particulars is not a general investigative tool, a discovery device, or a means to compel the government to disclose evidence or witnesses to be offered prior to trial. United States versus Gibson, which was in the Southern District of New York in 2001, rather, a bill of particulars is meant to enable the defendant to prepare for trial, to prevent surprise, and to interpose a plea or double jeopardy should he be prosecuted a second time for the same offense. And then it says United States versus Gamarano, and this was in the Eastern District of New York, July 18, 2007. Quoting United States versus Davidoff, Second Circuit, 1988. The test, quote, is not whether the information sought would be useful to the defendant, but rather whether it is necessary to the defense. So they basically said that it ain't necessary for them to prepare for the trial to know who these two people are. United States versus Sierra Garcia, Eastern District of New York, 1991. United States versus Payton, Southern District of New York, 1985, states, it is not enough that the information would be useful to the defendant. If the defendant has been given adequate notice of the charges against him, the government is not required to disclose additional details about its case. Accordingly, a defendant must show that the charges of the indictment are so general that they do not advise the defendant of the specific acts of which he is accused. Torres, Southern District of New York, 1987, Second Circuit, 1989. So it says, when a defendant seeks the identities of victims, cooperators, or government witnesses, a court may deny disclosure of the government, quote, sets forth specific reasons why such a request should be denied. United States versus Antico, Eastern District of New York, June 11, 2010, citing United States versus Cannon in the Second Circuit, 1976. Courts routinely deny requests for victims' identities in racketeering cases, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subordination of perjury. Denying disclosure where the government advanced specific reasons that the request should be denied, including the defendant's rank in the Genovese crime family and history of witness tampering, while the defense advanced a conclusory argument that he could not, quote, mount an effective defense, end quote, without disclosure. United States versus Gotti, Southern District of New York, January 6, 2004, cites that denying disclosure of the names of co-conspirators, witnesses, and victims because the government has a legitimate concern about the safety of those individuals it intends to call at trial. United States versus Kevin, Southern District of New York, April 7, 1999. The defendants are not entitled to the names of the victims at this time. The case charges the defendants with violent crimes presenting a clear risk of danger. And so they're basically citing cases where similar motions were made, I guess, and denied, and these were the reasons why it was denied. And so the defendant does not explain how learning the victims' names would alert him about the specific offense with which he is charged and prevent surprise. Gamera Reno, 2007. Rather, he argues that it is, quote, impossible to interview witnesses or, quote, to search for records, end quote, without the identifying information. In other words, the defendant seeks to use the victims' identities to conduct discovery, which is not the purpose of a bill of particulars. The government, on the other hand, advances detailed and substantive reasons to deny the defendant's motion, including his history of obstruction, intimidation, and witness tampering, his attempts to continue these efforts while incarcerated, and the nature and scope of the charged crimes. For example, the government cites the defendant's indictment for obstruction in the Northern District of Illinois and his efforts to intimidate witnesses and victims in this case, including by sending a threatening letter to Jane Doe number 6, who is Faith Rogers, and directing potential witnesses to, quote, pick a side, end quote, with him or against him. The government also has substantiated the defendant's ability to engage in obstruction while incarcerated by citing instances in which the defendant has circumvented prison protocols to communicate with third parties, including by abusing the legal mail system and using a prison staff member's telephone. Accordingly, the government's request to preclude the disclosure of the identities of Jane Doe and Jane Doe number 3 is granted, so ordered. And I just love how they can just throw out these generalities without any proof. So like when they were talking about he received this letter, and then he made this phone call. Is the Illinois, Northern District of Illinois charging him with anything on those 2 instances? Was anybody fired? How come we don't know the name of the lawyer who wasn't his lawyer that slipped him the note? There's no record of the letter or whatever was sent to him being entered into evidence in the case. And so it's just like they can just make up stuff and say, oh, this happened, and so this is why we're not going to give him that information. And then what else do we have here? And then here is a letter. Let's see, what is this? This is a letter to Judge Donnelly, and it was submitted by Richard Donahue, who is the United States Attorney, and says the government respectfully submits this letter in response to the defendant Robert Kelly's motion to waive Kelly's appearance at the conference scheduled for February 6th. And so we know he did do that by conference call. And so that was just the letter saying that they didn't have a problem with it. And then this was dated January 30th. And this was basically Steve Greenberg's request to them, asking that he not have to appear. And then this last document, let's see what this is. I may have already shared this, January 21st. And this is basically another request from Steve Greenberg. This was the motion to the judge saying that he needed the discovery on Jane Doe number 2, number 3. And then I just read to you the judge's response and denial of that request. And so that's all the motions. I did go back out there before I did this video to see if anything else had been filed. Nothing else had been filed. And then just to reiterate, the hearing that is coming up on March 5th is not a new hearing. It's not a new request that the judge is saying, okay, I'm going to take a look at this. The hearing that's taking place on March 5th was actually originally scheduled for like October 29th or October 30th. R. Kelly didn't show up for that hearing. The judge postponed the hearing to February 13th, I believe it is. And because of some other item on his calendar, he could not conduct that hearing this week. And so he's now pushed it out to March 5th. And once again, same situation applies as it did back in October, that even if he was to grant him the release, he still has to contend with New York. And so since the New York trial is going to start on July 7th, they're getting ready to start working on witnesses by sending out these questionnaires to 400 people in April or either May. Chances are New York, regardless, are not going to release him. And then I got to thinking, like with the Antonio Brown case, how they really didn't have enough, the NFL didn't at the time have enough evidence to suspend him on the accusations that the trainer had made against him. And so what they did theoretically is put him on this commissioner's list that basically kept him out of football for the entire season and kept any team from actually signing him to their roster, because then once they signed him to the roster, the NFL would have been forced to address whatever grievance was going on and either deny punishing him for whatever information they found out or punishing him. And so rather than go through all that, they just circumvented the situation and suspended him for the season, technically, even though they said that he just wasn't picked up by a team, he underhandedly had been suspended for the entire season. And so now in the off season, if anybody wants to pick up Antonio Brown, they can negotiate with the NFL behind the scenes to work out a deal and get him back on the field come next season. But then he's created all this other drama, by getting arrested and charged with assault and burglary for refusing to pay for furniture that he ordered shipped and driven across the doggone country, and didn't want to pay these people, and he ended up getting in all this trouble. And so now he's got to go see a psychiatrist and all this other stuff while he awaits trial. And so now the NFL is kind of feeling sorry for him. But I think just how they circumvented the system and suspended him for the year without technically suspending him, I kind of feel that the government is going to try and do that same thing with R. Kelly by keeping him locked up. And so even if they can't prove their cases or they can't get a conviction on everything, they can still at least say, okay, well, we had him locked up for, a year or 2 years, or however long it actually gets them, they actually get into the courtroom. And I really would not be surprised if, like I say, the Illinois case is delayed, that it doesn't start on April 20th or April 27th or whatever day they gave. And I wouldn't be surprised if the New York case gets pushed back again. And because I believe with the Chicago case in 2008, it really wasn't him delaying the trial for 6 years. It was the courts that was delaying the trial for 6 years. And so now that they have him locked up, they are in no hurry to bring any of these cases to court. And they think that as long as they keep him locked up, that increases their chances of him wanting to plea out and just confess to something. But as one legal expert says, it does him no good to plea out to any of these charges, because I think the maximum sentence on any of these indictments is 10 years is the maximum sentence. And so unless he pleads to one count for 10 years and then they dismiss all the other ones, it serves no purpose. But then on the back end of maliciousness, what they could do is, if he is found guilty of something, instead of him serving the sentences concurrently, which means that you serve the sentences at the same time, they could try to be nasty and say that the sentences have to be consecutively, which means if he gets 4 3-year sentences, he has to serve 3 years, then 3 years, and 3 years, and 3 years, instead of concurrently, where all 4 sentences would be served within a 3-year period. So guys, I'm going to go ahead and end this. I'm going to come back and do it. Well, not tonight. I'll probably do it tomorrow. Another video, just basically talking about YouTube in general that you guys might want to tune into. But anyway, that's it for me. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.